All right, you guys, thanks for joining us today. We're going to be going over C of A Part 2 presentation regarding contract negotiations. The 3 steps of contract negotiations are pre-negotiations, during negotiations, and post-negotiations. Pre-negotiations, what we do as a C of A team, we'll file an information request well in advance before we actually start negotiating the contract. We'll request the bargaining unit current employees roster, 1% of salary, which is a calculated cost of how much 1% of a cost of living percentage increase would be for everyone. All current policies, practices, and procedures, insurance plans, fringe benefits, and it could even be how much is in their budget. Establishing goals, we examine what we're trying to accomplish. So we will keep a folder throughout the time that we've in between contract negotiations to figure out what language do we want to add to the contract, what do we need to clarify, what are our goals. Surveys to members. A good contract involves as many people as possible, so we collect information from members using surveys, sometimes Google Forms, or just talking to people. Know your timelines, the period of time that you have to actually request and negotiate the contract. A mediator request. It's usually a good practice to have a mediator ready in case you guys, anybody comes to an impasse, so that way they could come in and help find a middle ground. And then you want to assign roles to your bargaining team. You could be a chief negotiator, a note taker, a proposal tracker, etc. Everybody on the table usually has a role. During negotiations, we'll usually first go over the ground rules. These are rules that are adopted by both parties to navigate the bargaining negotiations. Then we go over mandatory subjects of bargaining, which could be including hours, wages, working conditions, etc. We could talk about permissive subjects of bargaining, but neither party is required to agree to a proposed language on the ground rules, pension benefits for retired members, etc. There's many other permissive subjects of bargaining, which we'll cover a little later. Caucus. It's a meeting of the members called by one side to discuss with only that side. So say there's something to be said at the table and we don't want to say it in front of the other side. We call the caucus, we'll go meet, talk about it, come back. Good faith bargaining, that's basically the mutual obligation of the union and the employer to try to find and achieve a positive outcome for everyone included for contract negotiations. Impasse is the point in negotiations at which one or both sides have determined that no further action could be made by either party to reach a mutual agreement. The company can impose their last best and final offer when this happens. And then a tentative agreement, a written agreement reached by the parties during negotiations. What we sign off during negotiations does not mean anything because it's going to come back to the members for a ratification vote. So post negotiations is the vote when we bring it out to the membership to see if they want to accept or reject the contract that has been negotiated between their team and their employer. And then it's our job after it's been ratified, if it gets ratified, to make sure that we review every single change from the previous contract to the new contract to make sure nothing was added or deleted. And we'll usually use features on Microsoft Word or Adobe Acrobat to compare documents because it will pull out all new language or missing language from the previous to new one. Tips. We always want to be professional and civil at the table. We got to be reasonable. We got to keep track of all proposals, counters, and tentative agreements. Have a court reporter, which is somebody that literally transcribes every single word that is said at these meetings. Take detailed notes. Mark a time and date on each document. Ask questions to truly understand proposals. Keep the membership well informed. And we just got to be patient throughout the process. And last and most importantly, save everything. Our contract is a 40-year-old document, and there'll be a time where we might have an argument with Metro or employer over the interpretation of that language. And that language could be added into our contract since 1980. Probably nobody worked here since then. And so we're going to have to figure out what was the intention of that language. All these boxes in our union office are typically from years that we negotiated our contract, and we've saved all of everything, whether that's sticky notes or just whatever it might be, to figure out what was the intention of that language when we added it. So I do want to show you actual Metro proposals from the 2019 negotiations. What they came after was working time versus paid time for overtime. purposes. So basically right now you could request an annual leave day and still qualify for your days off or overtime, right? It's in our contract, that's why it's like that. They came after it to where they want you to work every single day to qualify for overtime on your days off. It's like that at VTA. We stopped them from making that change. The other big one was their proposal to change our medical coverage. They wanted to go from our original 95% coverage to 85%. This is an actual proposal for Metro. So let's do the math of what 85% compared is to the 95% coverage that we have now. So majority of us are in the Blue Shield HMO plan. And the monthly premium for the Blue Shield Access Plus HMO plan is $2,901.63 for an employee plus 2 or more in 2022. We pay 5% of that, right? So that's $145.08. That's what we pay monthly right now for that plan. If we would have went to 15%, that's $435.24 a month per person. That is $290.50 more a month. So for us to get them to back off on our medical was a huge win for everyone. And here's the proof right here. This is the 2022, our current premiums for our medical. This is the Blue Shield Access HMO. The monthly premium for the Employee Plus 2 is $29,0163. This is what we pay on a bi-weekly and monthly basis. So what would happen if we had to call a strike vote? Say they didn't back off on that proposal. On average, we negotiate our contract every 3 years, and there's always a possibility of a strike. A strike vote requires a majority vote from the entire membership. If the vote fails, this is the big part to understand, our employer could impose any working conditions which could include lowering wages and less benefits. The hypothetical scenario of the 85% compared to 95%, if we brought that to a strike vote and none of us were financially prepared to fight that good fight, which did happen in 2005 for 37 days with no pay, if that vote failed, now that's our new terms and conditions in our contract. And our members back in 2005 fought Metro off on our medical and were successful, but it took them 37 days without pay to do that. And one day, maybe our name is called to protect our contract too. And I do want to emphasize the reason why they backed off was our solidarity. You know, it takes all of us to stand together to make them to back off on our pretty awesome contract that we have here at Metro, because it's a 40-year-old document. This picture right here is every single contract that we've had since 1980. Look at how much bigger it's gotten throughout the years. And that's just us adding more and more benefits throughout the years. We've had a lot of great union representatives and members for our union that got us the contract that we have today. And we got highlights like our medical benefits, untouched and uncompared to with a lot of employers and workplaces. Our medical benefits are top notch. We get double time, almost unheard of everywhere. Where's anywhere offering double time on their 7th day? Annual leave slots. They're pretty good. Our accruals for annual leave. Annual leave counts as days worked for purposes of overtime, as I mentioned with that last proposal that they came for. Occurrences, pretty good. Base rep, that's a huge one. Almost nowhere pays their union representative, an employer pays a union representative to sit there to be available to represent their members. That saves us money. And it also gives the ability for us to have the time to represent to our best of ability for the union members as well. And we have contractual language, and that's why it's there. And then we have contractual meetings like our service planning and review committee, which happens once per month, our health and safety meetings that happens every quarter, and then our board of directors that happen once a month. And plus many other benefits.
When you're talking about base rep, the question for the peanut gallery. You think they could negotiate that during negotiations?
Absolutely. Every single thing in our contract is subject to change or for us to fight for. So it's our job to protect it any way we can. And then another tip is anytime you come across an old contract and a new contract, bolded language in the contract means it's new language that was added that year. So say we have, like I said, an argument over interpretation of a language. We'll dig through all the old contracts to figure out when that language was added, go through these boxes and figure out what the notes were to figure out what was the intention of that language if we have a disagreement with Metro. Bargaining subjects. The employer's bargaining duties do not end with the execution of a labor agreement. During the term of the contract, the employer must provide the union timely notice and a meaningful opportunity to bargain before making a material change in a matter not fixed by the agreement. Matters fixed by the contractual language may not be changed even if the employer offers to bargain. And there's categories for these subjects of bargaining, which are mandatory and permissive. Mandatory subjects of bargaining are terms and conditions that directly and vitally affect bargaining unit members. Examples include wages, it could be vacation schedules, workloads, it could be a couple of different things. As you can see, there's many mandatory subjects of bargaining. Permissive subjects of bargaining are terms and conditions that have an indirect impact on employees. Examples include advertising policies, automation decisions not based on labor cost, a closure of a facility or department for reasons other than labor cost, financial arrangements, hiring additional persons to existing positions, methods of distribution, product decisions, selecting supervisors, and subcontracting or transferring bargaining unit work because of basic change in operations. Basically, we need permission to bargain about these things. These are not mandatory subjects of bargaining. Note though, an employer may not make a change in a permissive subject without debating its reason with the union, but that does not mean that it can implement the change unilaterally. If the change has a substantial impact on the working conditions, wages and benefits, or job security of employees in the bargaining unit, the employer must give the union notice and allow bargaining on the effects before taking action. And this is a precedent-setting case from 2001. An employer has the obligation to give the union notice and an opportunity to bargain about the effects of the unit employees of the managerial decision, even if it has no obligation to bargain about the decision itself. So when a contract is silent to a certain issue, the following procedures must be observed before an employer makes a change in a mandatory or permissive subject of bargaining. The employer must give the union an advance notice. The union may request to bargain. The union may request information about reasons for the impact or the change, or the impact of the change. The employer must bargain in good faith with an open mind. The employer may not carry out the change unless negotiations reach an agreement or impasse. And if they don't follow those procedures, it leads to an unfair labor practice charge. An unfair labor practice is a policy or rule that is instituted without consulting the union is called a unilateral change. The change violates Section 8A5 of the National Labor Relations Board or a similar provision in the public sector agency like PERB. PERB can order the employer to rescind the change, compensate employees for any lost wages or benefits, remove any discipline imposed as a result of the change, and bargain in good faith before reinstituting the policy or condition. So what is the Public Employment Relations Board? Public sector. The Public Employment Relations Board is a quasi-judicial administrative agency charged with administering the collective bargaining statutes covering certain public sector unions in California. Each state has their own board and it can be named differently. Basically, it's a publicly funded agency designed in conflict resolution for employers and employees to make sure everything is running as smooth as possible. And it's also free of charge. Here are a few examples of an unfair labor practice by employers. A unilateral change, which we've already covered. Coercive questioning of employees regarding their union activity. Threatening employees or discriminating against employees because they participated in union activities. Promising benefits to employees if they refuse to participate in union activities. Failing to provide information. This one's a huge one. It's our job as union reps to investigate all disciplinary cases and all contractual violations as grievances. If Metro or our employer fails to provide us information for our investigation, that will be an unfair labor practice charge. And PERB or the NLRB could come in to force our employer or Metro to give out that information. A violation of Weingarten rights, something we covered on a previous presentation. If our employer or Metro refuses your right to union representation when they're asking you questions that could lead to discipline, That is a violation of your Weingarten rights, which is an unfair labor practice. And simply a failure to bargain in good faith. It prevents the union and employers from just saying no without having to follow or find a common ground. So how do you file a ULP? Unions can file an unfair labor practice charge with the NLRB or your state board, which is for us PERB, up to 6 months after illegal employer conduct. Forms are available on the NLRB website, nlrb.gov, for private sector unions only, or PERB, perb.ca.gov for public sector unions in California. That's us. So here are books and videos to learn more. Just Cause, a union guide to winning discipline cases. I provide the link right here. You can request the full NLRB and arbitration cases in the back of the book from the labor notes, and they'll give you this information for free. This is a great book to learn more about how to represent members in disciplinary matters, or even just to learn about your own protections as a union member. And I would suggest going through this link, because you could purchase this book for 20 bucks through this link instead of 400 to 500 bucks on Amazon or eBay or whatever that price is. The Legal Rights of Union Stewards. This is a book to teach you about your rights as a union steward, union representative. You are equal to management, and it shows you all of your rights as a union representative. The FMLA Handbook, to learn more about how the FMLA works. How to win a past practice grievance. No contract, no peace. This is a great one to learn about our protections during contract negotiations and how certain things can happen, and it also helps us strategize when it comes to finalizing a contract. And the last one, a labor law source book, where you can learn more about OSHA, FMLA, even just a couple of other labor law source books that are out there. But there's one book that we want you to read, which is your contract. This is the best union book that you could read. The orange one right here is the fixed route contract. The blue one is the Paracurs contract. The collective bargaining agreement, known as our contract, is the #1 union book to be familiar with. And that's it. Thank you for joining us today on part 2 for the Committee of Adjustment, and we progress through unity. Thank you.